greetings to our senior counsels. We are junior counsels in a corporate regulatory body in Malaysia, and we've been assigned case file 7. This information has been collected by the investigation officers, and this case file consists of black money from 2019. So to introduce the junior counsels, we are comprising of the 6 of us, which would be Ramanathan Elias Ashwin, Farah Nur Shahira, Akash Singh, myself, Nur Fatiha, Aino Patrisha, and Nitish Padmanathan.
Okay, so for the introduction, corporate governance sets the rules for how a business is managed, emphasizing responsibility and accountability. Transparency, a key aspect of governance, ensures that important information is shared with stakeholders such as shareholders and investors. Financial reporting following accounting standards provides insights into a company's financial health. Non-financial transparency, including governance practices and CSR programs, help stakeholders assess a company's social responsibility.
Alright, moving on to the facts of the case. I'm Farna Shaira, and I will be explaining about what really happened in the case of case 57. So we can see numerous corruption-related concerns in this case. Actually, Dehan Bank was bought by the Star Fund by lovely cheap sum. The bank is valued at least 70 trillion won, yet it will only be sold for 1.7 trillion won. So the public, it arises concern and confusion in the public, and thus they insist that punitive sale to be done. So this caused numerous accusations have been leveled at Star Funds, including suspicions of corruptions and allegation that they manipulated the BIS ratio. So they sent a fax claiming that Dehan is in financial distress and has a low capital ratio. And as a result, the Financial Supervisory Service allowed Dehan Bank to be sold for less money, thanks to this document. So additionally, Star Fund is also accused in engaging in money laundering, which they concealed by establishing a paper company using borrowed names and addresses. Regulators and CK law firm insolvent Dehan Bank to facilitate Star Fund's takeover, contributing to the manipulations of the BIS systems. Okay, in this case, Yang Ming-Hyu, which is the prosecutor, is also framed by the Star Fund and being protected by the CK law firm. So we can see that not only Star Fund is allegedly to involved in corruptions and manipulation of BIS ratio, they also have many more issues. For example, framing innocent individuals. So thus we as junior counsels would like to investigate this case deeply. So moving on to the parties. So in this case, the parties is the Star Fund, which is an investment company who is accused to be involved in fraud and corruption by manipulating Dehan Bank financial status. And the next one is Financial Supervisory and Regulatory Service. This is South Koreans, based in South Koreans. They are responsible for examining and supervising financial institutions under the broad oversight of the Financial Service Commissions.
Now let's see the issue. The issue of this case actually revolves around the question of whether Star Fund's acquisition of Dehan Bank was executed with a veil of deception and perpetrated an act of fraud. We, the junior counsels, observed 4 misconducts. The first one being the controversial sale of Dehan Bank to Star Funds that sparked concern due to its dubious nature. It appears that Star Funds, with their shrewd business acumen, managed to orchestrate a deal that not only guarantees them a substantial windfall, but also leaves room for astronomical profits through the subsequent resale of the bank. However, what makes this transaction particularly concerning is the underhanded tactics employed by Star Funds to manipulate the BIS document. When it comes to corporate governance in Malaysia, Section 213, Subsection 1 of the Companies Act 2016 explicitly mandates that directors must consistently act in the best interest of the company, demonstrating unwavering good faith. However, the decisions undertaken by the directors of Star Fund during the acquisition of Dehan Bank deviate significantly from this honorable standard, lacking authenticity and sincerity. The second misconduct is Star Funds manipulating BIS documents to misrepresent the bank's financial state to acquire a lower price. Despite the bank actually being in a healthy position, Star Funds cunningly fabricated a narrative of financial turmoil to justify their acquisition at a presumably lower price. This deceitful act involves the manipulation of the BIS documents, wherein false information was injected to paint a picture of distress and instability. By misrepresenting the bank's financial health, Star Funds strategically positioned themselves to acquire the institution at a significant discount, paving the way for substantial profits upon its
Under the
resale.
third misconduct, Star Funds use an intricate network of paper companies for money laundering. To further complicate matters, Star Funds resorted to an intricate network of paper companies to obfuscate money trails and facilitate illicit money laundering activities. By utilizing borrowed addresses and names, they created a myriad of fictitious entities that serve as a smokescreen to conceal the movement and origins of their funds. This elaborate of deception not only allows Star Funds to avoid detection, but also perpetuated the cycle of financial impropriety and illicit activities. The fourth misconduct is that the Financial Supervisory Service approved falsified documents, suggesting a lack of oversight and corruption. While Star Funds must shoulder a significant portion of the blame for their unethical actions, it is crucial to highlight the complicity of the Financial Supervisory Service, a branch under the Korean government. Astonishingly, the falsified BIS documents containing misleading information about Dahan Bank's financial condition were blindly approved by this regulatory body. This raises serious questions about the integrity and diligence of the Financial Supervisory Service. Their apparent failure to scrutinize and identify the discrepancies in the text documents suggests a worrisome lack of oversight and accountability. Furthermore, it appears that the approval of these falsified documents led to the promotion of the officers involved, indicating a clear case of malefied intentions and corruption within the regulatory system.
In contemplation of the Malaysian legal context, we take a look at Section 213 subsection 1 of the Companies Act, which actually provides for the duties and responsibilities of directors. Now, under subsection 1, this provides that the directors shall exercise their powers for the right purpose in the best interest of the company. So we see from here that the purpose of these powers have to be lawful, right, and in accordance with the functions of the company. And there's also a requirement for directors to put the company's interest over any personal interest. So we see in the case of staff that the misconduct was in complete contravention of this particular provision, as this act of acquiring Dahan Bank was through unlawful means, and this contradicts the use of power for a proper purpose. Additionally, we see that there were acts of incorporating paper companies together with borrowed names and also falsification of documents for money laundering, and this was done for personal benefits of the directors, and this is also a criminal offense. Now, we take reference from the case of Kawin Industrials Nia Berhad in liquidation and Teh Tong Sung, where the act of the director of the company was held to be unreasonable and not in good faith, as the payment of company funds for the director's personal gain was authorized by himself. So, referring this to the case of Star Fund, it is also of a similar position, as there is no element of good faith in any part of the case, and the main intention of Star Fund was to gain profits at a lower cost, and this unlawful method was used for this purpose. Next slide. So we see there's also a contravention of Section 219 of the Companies Act, which provides for the general duty to make disclosure. So the sale of Dahan Bank to Star Fund was of a dubious nature. And since there were no details, no enlightenment regarding these unlawful acts to any parties which are related to the company, be it the members and also the shareholders. So the sale was also coupled with various malefied actions and procedures, such as the manipulation of BIS documents and also the creation of paper companies for money laundering. So on the outset, this is viewed as something that is a normal sale by Star Fund over a bank which is unstable and as a result faced reorganization. So we now see that from the Malaysian context, this is undoubtedly a violation of duty of disclosure, because Section 219 subsection 1A provides that directors are required to give notice in writing about all the particulars related to their interests. So this also includes commercial interests, and this was contravened by the directors of Star Fund. So we also see that there is no compliance with Clause 1 of the MCCG 2021. Now, the MCCG is a code for corporate governance, and corporate governance is also defined under this particular clause. So the fiduciary capacity requires directors to act in the best interest of members of the company as a whole, and not any particular party within the company or outside the company. So this element of integrity, on the other hand, also requires directors to act honestly and faithfully. However, we see in the case and conduct of Star Fund, the fiduciary capacity was not met by Star Fund, and therefore there is no intention to act in the best interest of the company. These benefits of the members of Star Fund, such as the shareholders, were not the priority of Star Fund, and indeed, we see that the focus was on acquiring Dahan Bank and also for the purpose of money laundering. So there's also a contravention of Clause 3.0 of Principle A of the MCCG. Now, Clause 3.0 emphasizes that the board be committed to put forth a good business conduct and a culture of governance relying on integrity and transparency. So in order to fulfill this, the guidance term under this clause requires a board to have a code of conduct and ethics, and such code will then list down measures to prevent any unlawful activities. So in Star Fund's case, the clause was not fulfilled because there was a breach of element of integrity and transparency. So to establish a code of conduct would have ensured that there will be a prevention of such misconduct in that company. Next slide, please. So there's also an inapplicability of the listing requirements of Bursa Malaysia Securities Berhad, BMSB Chapter 9. So if you look at the Malaysian context, Chapter 9 of the listing requirements are usually referred to in order to understand policies regarding duty of disclosure. But this only applies to listed issuers of BMSB. So this is also the meaning of listed issuers is seen in Clause 1.01, and it defines listed issuer as either a listed corporation, collective investment scheme, business trust, or an issuer of any other security. But in the current case, Star Fund is a private equity fund, hence it is not possible to invoke any clause within this chapter.
Thank you very much, Mr. Akash, and as well as my learned friends. I believe that a sufficient enlightenment has been provided on the misconduct of Star Fund as well as the contravention of the law on a Malaysian context. Based on this, as well as based on the research that has been made by us, junior counsels, there are certain legal actions that could be proposed or recommended, and this would be seen from the perspective of a common law action as well as a statutory action. So to begin with, under a common law action, the only resort based on this case or based on misconduct of Star Fund is an account of profit, and this will be explained in the case of Regal Hastings, whereby in this case, former directors of a company were sued, and the suit was brought against them by the newly appointed directors of the company who were the plaintiffs. And the ground for this suit or action against the former directors was that profits were made by the former directors using their offices, and an account of profit was not made. The former directors did argue that these profits were made on a good faith and on a proper basis. Nonetheless, the court imposed an obligation on the former directors to make an account of profit, despite them making such profits in a good faith capacity. Applying this to the misconduct of Star Fund, the directors or the board of directors in Star Fund have not made profits in a good faith, and instead there were many various malafide actions coupled together with it. And applying this case, an obligation to make an account of profit would also be imposed based on this. And moving on to the statutory actions for the misconduct of Star Fund, and this would be based on the Companies Act 2016, whereby Section 213 and Section 219 have been respectively violated by the directors of Star Fund, as explained earlier. Section 213 provides for the duty of directors to act in good faith and best interest of the company, and Section 219 provides for directors to make a disclosure on the activities of the directors. And as a result, the contravention was explained quite well earlier. And based on this, Section 213, subsection 3, provides that a director who contravenes Section 213, which is the duty to act in a good faith and best interest of the company, will be liable for an imprisonment for a term not exceeding 5 years or a fine not exceeding 3 million or both. Similarly, under Section 219, subsection 6, Clause A, provides that a punishment would be imposed on directors for contravening their duty to disclosure, and the liability in this case is also an imprisonment not exceeding a term of 5 years or a fine not exceeding 3 million or both. And it is quite evident that the directors of Star Fund have contravened both of these duties under the context of Malaysian law under Companies Act. And on this basis, a legal action could be initiated against the directors of Star Fund.
Okay, thank you. In the conclusion, the sale of Dahan Bank to Star Funds in the film Black Money was conducted in a dubious manner, lacking transparency and disclosure. Therefore, to address this misconduct, legal action should be taken against the company and its officer, and compliance with corporate governance principles should be enforced. Thank you.
Hence, we hope that this presentation to our senior counsel helps and assists you in research on this particular case. Thank you.